Thank you so much. It is quite an honor for me to be here and to talk about searches incident to an arrest and the application of the exclusionary rule in federal courts. Now, of course, our modern day jurisprudence and what we understand about the Fourth Amendment was really formed during the seesaw turbulence of the 1960s. If you think about the history, 1961, that's President Kennedy's first year in office. The High Court decides Mapp versus Ohio and applies the Fourth Amendment to the states via the 14th Amendment. In 1967, after the Summer of Love in San Francisco, the High Court decides Katz versus United States and holds that the Fourth Amendment protects people and not places. In 1968, after the terrible assassinations, of course, of Dr. King and Bobby Kennedy, the High Court decides Terry v. Ohio and determines that reasonable suspicion is enough to justify a brief investigatory detention. In 1969, 1 month prior to the first man walking on the moon, the High Court decides Schimel versus California and limits the search incident to an arrest to the person's body and the area within his immediate control. Now, my law enforcement friends told me when I was in federal practice that after Schimel, law enforcement created a different type of doctrine called portable Schimel. And that is, if you arrested the person, the suspect, in the kitchen, and you wanted to search the bathroom, well, you simply moved him to the bathroom, and then you could justify the search. Well, clearly, the doctrine of search incident to arrest expanded to such a great degree that in 2004, in the case Thornton versus United States, because obviously the doctrine had extended to cars with the decision Belton versus New York in 1981, in Thornton, the driver of the car was outside of the car and taken, arrested, and locked in the back of a patrol car, which then allowed the officers to search. Clearly, Thornton wasn't in any capacity to be able to reach for his car or anywhere, and nor was the car within his immediate control. But in holding and upholding the search, Justices O'Connor and Scalia, in their concurrences, complained that essentially the search incident to an arrest had become a police entitlement, was the word that they used, rather than this limited exception to the Fourth Amendment, and they wanted to rein it in. And they did so in 2009 in Arizona v. Gantt. Again, Rodney Gantt was away from his car. He parked it in a driveway. He was in somebody's yard. He was arrested based on an arrest warrant for driving with a suspended license. He was again locked in a patrol car, handcuffed, not near the car, but based on past practice, the police searched the car, finding incriminating drugs. In upholding the suppression of those drugs, the Supreme Court essentially reined back what had been happening in these searches incident to an arrest and said, from now on, when you go to a car, the only way you can get in it is to be able to have the arrestee right next to it, because the justification for the Schimel rule is, number one, officer safety, and number two, to preserve evidence from destruction or concealment. So either the driver or the recent occupant of the car is right next to it, which may be another reason to do portable Schimel if you think about it, or to preserve evidence of arrest. And since Rodney Gantt was arrested for driving with a suspended license and there was no evidence to retrieve the car, the court upheld the suppression. Now, why Gantt is so unusual, it's because it was the first time that the exclusionary rule had been vindicated in the High Court since, one scholar noted, since Marshall and Brennan were on the High Court. And this was in 2009. Now, the exclusionary rule first comes to life, of course, in 1914 in Kansas City, Missouri, where this small-time lottery cheat, Fremont Weeks, his house was invaded. The police got a key that they found, and they seized documents which they used to convict him. And when his case made it up to the High Court, the court found in his favor and said, essentially, you cannot sacrifice our Constitution when you seek to put people in jail. The fundamental principles of law must still apply in all circumstances. And so the remedy for a Fourth Amendment violation is going to be to exclude illegally obtained evidence. So too, though, the fruit. Now, fruit of the poisonous tree, that was first mentioned in Silverthorne Lumber in 1920, and that was a tax case. But it was really coined by Justice Frankfurter in the Nardone versus United States case in 1939. In that case, papers were seized, telephone calls were intercepted, and the Supreme Court said, we are absolutely going to suppress not only the conversations, but all the evidence that you learned and all the knowledge that you learned in addition to those conversations. But surprisingly, the court also said illegally obtained evidence may still be admissible if there is enough attenuation to dissipate the taint. Now, this was in 1939, and the attenuation doctrine essentially says, since the exclusionary rule's main purpose is to deter future police misconduct, that's its reason for existence. If there's so much space between time and distance, between the initial illegality of the law enforcement officers and the retrieval of the evidence, to make the force of deterrence minimal, well, then there's no reason to do it, and we're going to admit the evidence. The other two exceptions are, of course, independent source. You get the evidence from something unconnected to the initial illegality, or inevitable discovery. The officers would have found it regardless of their activity. Now, as this is happening, that these exceptions are weakening the exclusionary rule, it happens around the same time that the criminal justice pendulum shifts away from sort of the rehabilitative focus of the 1960s, and we start to get things like mandatory minimum sentencing, 3 strikes you're out life sentences. Until 2005, we had mandatory federal guideline sentences, and sort of this harsh doctrine in this light. The cases that the court decides to take actually take aim at the existence of the rule itself. And the first such case is Hudson v. Michigan in 2006. Now, in this case, it's a simple knock and announce case. Officers in Detroit have a valid arrest warrant, and they're going to go and into Mr. Hudson's house, I think, for drugs and cash. They do not wait the obligatory 15 to 20 seconds that Banks says you should wait. They kick down the door, I think, after 3 seconds, and they seize the evidence. Now, the High Court says that the seizure of the evidence and the illegal entry is not a but-for causation of the seizure of the evidence. That is, they're wholly unrelated. Now, this is something that I heard Josh talk about. Wayne Lefebvre, he's a Fourth Amendment giant. He actually says that type of reasoning is bogus. But it's one in which changes the lens in which how the High Court will look at how it examines police behavior, specifically with its interaction with citizens and seizing evidence. Now, imagine the scales of justice, because what the court does in Hudson is they do this cost and benefit analysis. Since the primary purpose of the exclusionary rule is deterrence, if the officer's behavior is intentional and their malfeasance is gross and wanton, then deterrence, the weight of deterrence, is exceptionally heavy, and therefore they're going to exclude the evidence because it outweighs the social costs of letting the guilty go free. Because, as the court says, exclusion is always the last resort and not its first impulse. Conversely, should the officer's behavior be merely negligent it's an isolated act, it's some mistake made in good faith, then the deterrence is light. And it will not be outweighed by the social costs of exclusion. The society will win, and we will not let the guilty go free. And it's within this framework that the court starts to examine a number of mistakes and categorizes mistakes as just something that happens rather than something intentional. Now, this is very easy to do because, as you know, in 1986, the High Court held in Wren versus United States, an officer's intent is completely unrelated to whether or not there's been a Fourth Amendment violation. And they actually, with this cost-benefit analysis, in my perspective, I think they start to treat the public as Blanche Dubois in A Streetcar Named Desire. If you remember the end, when Blanche is being carted off, she says, "Whoever you are, I have always depended on the kindness of strangers." And the High Court actually believes and inserts in its opinions that the government is always acting on a good faith basis. But we know from history, especially in the realm of criminal procedure, this is not always true. If we just look at, for example, Batson v. Kentucky, 1986, says you can't use race as a basis to exercise a peremptory challenge unless you give a race-neutral reason. But look at all of the convictions that have been overturned because of Batson violations. Even just 2 weeks ago, the Supreme Court heard oral argument in Flowers versus Mississippi, where the defendant has been convicted 6 times of the same 4 murders, twice. Once his conviction has been overturned for a Batson violation. And you know it's bad when Justice Samuel Alito says, "The history of this case is very troubling." You know it's got to be really bad. But even Missouri v. Seibert, there's another example where the double interviewing technique, law enforcement as a way to negotiate the requirements of Miranda v. Arizona, a way to get around it. They interview the suspect, become friendly with the suspect, have the suspect trust them and confess, then give the Miranda warnings and cleanse the subsequent confession and just say essentially, "Now just tell me what you told me." Now the Supreme Court outlawed that in 2004, but it shows that, of course, the government is resourceful for getting around certain rules when it's so inclined. I know my co-counsel, Mr. McNeil, is going to come up here, and he's going to tell you about racial profiling and the New York City stop and frisk procedures. So I find that the court's analysis that we could just look at the court's, at law enforcement officers' mistakes as benign is somewhat misleading given the history, but it's something that they do. And so there's many mistakes that start to be made in these cases where the exclusionary rule is not going to apply because it's isolated and it's simple negligence, and really it's not that important. First case, Virginia v. Moore, 2008. We have the police looking for Chubbs. Where's Chubbs? We know he's driving on a suspended license. They're looking for him. They see him. They arrest him for driving with a suspended license. But unbeknownst to them in Virginia, it's not an arrestable crime. Something that you just get a summons for. They find drugs, goes up to the High Court, and the High Court says, well, you know what? It would be crazy for us, essentially, to have to adopt and incorporate all state laws on search and seizure into the Fourth Amendment. So we're not going to do that. The reality is the police had probable cause. They thought they had probable cause to make an arrest. That's good enough, and the evidence will not be suppressed. Mistakes about law supporting arrests similarly in Hine versus North Carolina. The officers are watching Mr. Vasquez, who looks nervous. And so they pull him over for having just one working tail light. Now, under North Carolina law, you can actually have one working tail light. It's not a violation, but the officer didn't know this. Hine, whose car it is, he's sort of sleeping in the back, seat covered by blankets. They ask for consent to search. I still, to this day, do not know why. And I tell my students this: why, if you have drugs in the car, would you allow a consent search? I don't understand. Does the word no not come to you? And I know we've all talked about it. I've heard everybody say you feel you can't refuse. But really, when you know that they're going to find the drugs. So they consent. The drugs, Hein obviously moves to suppress the drugs. It goes through this tortured history in the lower courts, some finding in his favor, some not, goes up to the high court. And they say, you know what? The law was actually unclear. It said rear lamp, brake lamp, and there was no intermediate court decision discussing the law, so the officers were confused. It was a good faith mistake. Good enough the evidence will not be suppressed. Mistakes in computer databases. Just like Chubbs, David Moore, the police were gunning for Benny Herring. Benny comes down to the town. He lives in Alabama. He wants something from his impounded truck. Officer Anderson calls the court clerk and says, hey, we got any arrest warrants on this guy? Finding none, he says, hey, let's call our neighboring sister county, Dade County, which they do. Lo and behold, there is an arrest warrant. Now, by this time, Benny's left the impound lot, driving down the street. They pull him over, arrest him, do a search incident to an arrest, and find drugs and a gun, and he's a felon, he can't have a gun. The question becomes, is this mistake, because it turns out the warrant had been recalled 5 months earlier, is this mistake something that would justify suppression? And the court says absolutely not. Now, it does point out, the court does say, well, if this were a recurring violation, if this were, and we're not saying that every mistake in a database would not trigger the exclusionary rule, but in this case, it's simply some random act of negligence. It's a record-keeping error. Clearly, the exclusionary rule will not, in the court's language, pay its way. Then we come to Mr. Strieff. Now, Mr. Strieff, his case begins in 2006 when an anonymous tip notifies police that there's drug activity going on. Officer Fackrell spends about a week, but he only spends about 3 hours looking at people, and he notices there are short-term visitors and a lot of foot traffic. Clearly indications of drug activity. One day he sees Strieff come out of the house. He doesn't know when he actually went in, and he sort of follows him in an unmarked truck, pulls up to a 7-Eleven parking lot and gets out and says, hey, what's going on with that house and that drug activity? Now, Strieff doesn't feel like he can refuse. At some point, the officer asks for identification. He gives it to him. He does a warrants check, and lo and behold, there's a warrant out for his arrest due to some traffic violation. He searches him and finds methamphetamine and a scale. And the issue is, does the initial illegal stop, which the state concedes, there was absolutely no reasonable suspicion, he didn't know anything about Strieff, just saw him come out of the house, does that somehow invalidate or taint the fruit of the finding the arrest warrant? But just like in Hudson, the court finds that there is no connection between the initial stop and the discovery of the warrant. And they do that because of their focus on the attenuation analysis. Now, as I mentioned, attenuation was first mentioned in 1939, but it's really developed in the Brown versus Illinois case of 1975, where Brown is held at gunpoint, essentially, unlawfully arrested, makes incriminating statements about a murder, which he then tries to suppress unsuccessfully. Case goes up to the Supreme Court that finds in Brown's favor because they find that the attenuation doesn't apply between the initial illegality and the statements that are eventually cleansed by Miranda. Now, if you read the case carefully, the Brown court talks about a number of factors one should look at in applying the totality test, and doesn't really outline 3 factors. But the Supreme Court, in citing Brown, outlines these 3 attenuation factors that they rest their Strieff decision on, saying that the temporal proximity between the unlawful search and seizure that actually favors Strieff because there was a very quick time between the two. And they really rest their hat on the presence of an intervening circumstance. finding that the discovery of the arrest warrant broke the causal chain. It was the intervening circumstance that allowed the government's actions to essentially be cleansed and legal. Now, the case is really known for the dissent of Justice Sotomayor, and here she is at age 2, and she talks about, in New York City, she chastises the majority opinion by saying, you don't know the real realities of what it's like to be a member of a community of color that can really suffer additional indignities by these unlawful stops. And if you read her footnotes, they read like a syllabus in a diverse literature course. She cites Soul of Black Folk. She cites the new Jim Crow. And she essentially says, you have now given, by this majority opinion, carte blanche to officers to essentially go and search whoever they want, because given the number of outstanding arrest warrants, and she cites, of course, Ferguson, where 80% of the adult population, the Department of Justice found in their investigation after the death of Mike Brown, 80% of the population had arrest warrants. And she essentially said, now you're going to just let officers sit there and just stop people, even without reasonable suspicion, searching for warrants in the hopes that you find something incriminating. And she found that untenable. Justice Kagan also dissented. She cited actually Pennsylvania statistics saying there's 12.8 million people in the Commonwealth and 1.2 million outstanding warrants. And given that these warrants are all floating around, it's highly likely that you're going to find something, even just if you stop people. But clearly the majority did not agree. So, motion practice tips. In the end, of course, defense counsel, a wise lawyer once told me, you're only limited in your discovery motions by your own imagination. Clearly, you want to get as much evidence as you can to prove that this negligence or mistake is not isolated, but it's a recurring pattern. To do that, you should seek out your fellow members of the defense bar and see if they have transcripts of officers involved in different hearings and collect those. As the government, clearly you have the burden, but the arguments are on your side that any mistake made was unintentional and in accordance with the officer's belief about the status of the law or the facts at the time. I hope this has been helpful.